your honors here today. Um, this is a case that arose out of the Macon County Juvenile Court, and it's one that all cases as practitioners you take very seriously, but this one as a father myself, a divorced father, and a father that's lived through a relocation case personally, this one has worked on me pretty good. And the reason it's worked on me pretty good is that I don't know any easy or light way to couch this, but the order from the juvenile court in Macon County, respectfully, is one of the more egregious orders that I've seen in the 20 years of my practice of law. I've argued this case. This is our second time, and I'm hopeful that while I'm sitting here on Zoom, and I'm hopeful that I've gotten, like wine, a little bit better as I've aged with the argument. And in looking at this and preparing for your honors today, I'm taking a little bit of a different approach, but I think it's an important approach to articulate and give you judges an opportunity to kind of see the taste and the flair of the court order. And so I don't want you guys, judges, to think that I'm treating you, when I read to you a little bit, that I'm treating you, just reading to you like I would my fourth or fifth grade child. But I think it's important to go to the order. And when you look at the order that Judge Witcher in the Macon County Juvenile Court levied, I think there's some pertinent parts to articulate to the court. And I'll start with on volume 1, page 84 of the record. Part of what Judge Witcher said in his order after 2 days of testimony is that he restricted my client, Mr. Bailey's, parenting time to no more than essentially 55 days a year. And when he did that, he gave some reason and some basis for doing that, some of which were his participation at baseball games because he stood out in left field or right field where the young man was playing. He was encouraging his child in those circumstances. He was giving his child baseball apparel, baseball equipment, gloves, and things of that nature. But not only did Judge Witcher restrict his time to 55 days, he also essentially made the mother in this case judge, jury, and special commissioner. Part of his order, and I'll read it to you for the court to consider, is that based upon the father's past conduct in attempting to control mother's behavior, mother should be granted the right to cancel father's visitation periods without any restrictions for whatever reason she deems appropriate. Mother should not have to give father any reason for her decision or prove to any court that she has a valid reason to cancel father's visitation. Essentially what Judge Witcher did in this case is that he's given the mother the opportunity at her own whim, at her own choosing, to deny the father visitation. And not only does she have that right based upon this court order, the court order further allows the mother and tells the father that while doing this, and if this is changed in any sort of way and not given any reason for the restriction, that the father can't go to court and complain about it. And quite frankly, judges, I would suggest to the court that this is unconstitutional. Essentially, Judge Witcher, throughout this case and throughout his order, and page 84, page 85 of volume 1, and even into page 86 of volume 1, has restricted his ability to come back to court, to ever come back to court. And I don't know that, well, I'm pretty sure that restriction is unconstitutional and not allowed. There were other.
Did you specifically raise that as an issue? I'm trying to see that in your issues on appeal.
What I did, Judge Stafford, is I raised 3 essential issues on my appeal: the due process issue, and I will get to that, and then in the second part, the misapplication of TCA 366406 on the emotional abuse. I touched upon those types of issues, the restriction of his ability to parent this child based upon a lack of, or based upon the proof that Judge Witcher felt that was presented on emotional abuse. So I touched upon these issues throughout my arguments, but it wasn't, I wouldn't suggest to you that it was a Roman numeral issue that I proposed to the court. So to answer your question, it's throughout my argument in all three sections. He wasn't given proper notice. What essentially happened is we tried this case on July the 9th. After the first day of trial, the mother filed a petition to modify the parenting plan. I want to believe that was on July the 12th. We come back on July the 16th to argue the case. Obviously, we weren't put on any type of notice that the father's parenting time would be restricted in any sort of way. And so I felt that there was a due process argument there that needed to be made, and that was my first Roman numeral. And then the second Roman numeral is I talked essentially about the emotional abuse standard without any type of medical proof, any type of expert proof. The court found that my client had emotionally abused the child and emotionally abused the mother. It appeared based upon the ruling and again in volume 1, page 84, 85, 86, that the judge went back and really looked at prior orders back from 2013, 2014 in crafting his order. I would remind the court, not necessarily that you need to be reminded, I apologize for couching it that way, but juvenile court is a court of rehabilitation. Juvenile court is a court where you're trying to rehabilitate individuals, trying to help young people, trying to right wrongs. Even if you were to take what happened back in 2013 and 14 as if it was the absolute truth, then my client should be given an opportunity to come back to court and show that circumstances had changed, the child's circumstances had changed, that the parenting plan that was entered back in 2013-14 was no longer in the child's best interest. And it appeared based upon the ruling that Judge Witcher used a lot of old facts in crafting his ruling. And he essentially was complaining about things that the mother said. And judges know that there's a reason why people are divorced. There's a reason why people are in court. They can't get along. And if you believed everything that an adverse party said over the other, then the floodgate of litigation would be wide open. And in this case, by the court finding that there was some sort of emotional abuse without any type of evidence to indicate from an expert that the child was suffering and want and need, had been physically harmed in some sort of way, you just simply can't make that finding. And so I felt
let me ask you a couple questions, or start off with one anyway. And that when you were trying the case and when the first notice of I guess the request to restrict visitation appeared, did you object?
I don't want to represent that I objected when I didn't. I just simply don't recall. I remember we had a long discussion about that. I remember Judge Witcher asking me some questions about that. I remember Judge Witcher saying we weren't going to go forward on her petition. And even in his order, I think he dismissed it at that time. I think I do recall him asking me what he should do with that. And I said, I think because you're the judge, you can do what you want with it. You can, there's a material change of circumstances. It had been conceded that there was a material change of circumstances. And I suggested to the court, he said, well, what do we do with that? And I said, I think you can either adopt my plan and craft a plan that you deem to be in the best interest of the child. And so I don't want to represent to you, Judge Stafford, that I objected to that. I know that it seemed like I did object to it, or we had a long discussion about that, but I don't want to represent that I objected. I know I was frustrated by the fact that we had a day's hearing on July the 9th, and then there was a subsequent motion for a psychological test filed within a week's time of our next trial. And I didn't think that was proper. We certainly weren't put on notice about that. And so to answer your question, I can't say that I objected to it. I know that we had a long discussion about it.
Okay. Here's what I'm trying to figure out is basically how this all transpired. You're getting ready to try the case. there's a request to restrict the visitation. The trial court at some point in time then basically dismisses that request for whatever the reason may be. But all the evidence essentially comes in. Would that be accurate?
That is accurate. I mean,
Okay.
the evidence was that my client testified, the mother of the child testified, her husband testified, the maternal grandparents testified, my client's daughter testified, and my client's former girlfriend testified, and that was all over the course of a 2-day period, Judge.
Okay. All right.
I would suggest too, and one of the things that I want the court, essentially page 9 of 12, page 85 of the volume 1, is that I think it's important that if the court has found that the father has committed these acts, is to ask what acts has he committed that are so egregious that his parenting plan, his parenting time would go from 116 days to 55 days to essentially no more than 2 days at a time, no summertime visitation, no extended Christmas visitation, no fall break, spring break. How can you create a bond with your child? How can you encourage your child if you're told you've got to sit in the spectator section and not say anything? How can you have a bond with your child if these sorts of rulings are put down? My time is up. I apologize.
All right. Thank you. You've got your rebuttal time.
Thank
We will
you.
now hear from the appellee. You're going to need to unmute, I think. You're still not unmuted. There you go.
Okay. Good morning. May it please the court, I am Lisa Cothran of the Macon County Bar. I'm for the mother, and we ask this court to affirm in all respects the judgment of the Macon County Juvenile Court and award attorney fees for the appellate level. Mr. McCarter argues that his client's time should not have been reduced for various reasons. I submit that his arguments are without merit. Mr. McCarter argues that his client should not have been ordered to reimburse mother's attorney fees at the trial level. Attorney fees are in the discretion of the trial court. Father was given the opportunity to file a response to the affidavit of attorney fees that was submitted, and he chose not to do so. Again, I submit that this argument is without merit and that his objection to the attorney fee issue was waived by not filing a response to that. The statutes that govern the court when making residential provisions for a child come from Tennessee Code Annotated 366404B. And the most often cited case on this point is the Armbruster case. Father conceded during the trial that this was a schedule modification petition, not a custody modification petition. The determination of a parenting plan is typically referred to as a 2-part inquiry, but in reality, the second part has 2 subparts. So perhaps more accurately, we can consider it a 3-part inquiry. First, the court has to find that there has been a material change of circumstance affecting the best interest of the child. That was conceded by both parties, and the court made specific rulings as to the basis of the material change. If there is a material change, 404B sets out the process that must be followed. At this point, we normally talk about the 15 factors for the best interest analysis. But first, there's a detour. The court is required to consider Tennessee Code Annotated 366406 to determine if the limitations of that statute are dispositive. In this case, the court found that those limitations were dispositive, though it did follow up and discuss the 15 best interest factors in addition to that. The court followed those statutes meticulously. There had been a previous order in 2013 that father had engaged in inflicting emotional abuse on numerous family members over the years. and that father had a very controlling behavior toward women with whom he had relationships. This court found that his bad behavior, quoting, bad behavior has not improved, but has actually gotten worse, end quote. It had continued and it now included this child. The court referenced the pattern of emotional abuse set forth in subpart A2 and also found under part D that the father's conduct was having an adverse effect on this child. The court issued its separate findings of fact and conclusions of law, which totaled 11 single-spaced pages, detailing the specific bases for the ruling and making credibility findings, which he found that father was not credible and that mother, as to her testimony, was. Father,
Do you have to have any medical proof or professional proof to make these type findings by the court?
no, Your Honor, the court specifically said he does the dependency and neglect docket as well, and he found that he did not require expert proof to make a finding of emotional abuse. The father is the petitioner. He's represented by experienced and very able counsel. He is charged with the knowledge of what the law is when he filed his petition. Father could put on his proof, mother could answer, and she did, denying most of his claims, and he took the risk that the court would find the material change was not in father's favor, but adverse to father. Father's counsel even conceded at the end of the first day of hearing that if material change was found, the court could, quote, fashion a parenting plan that's in the best interest of the child or a custodial arrangement that's in the best interest of the child, whether it means to increase father's time or decrease his time. That's how I believe the law states. If you find a material change, then you can do whatever you deem fit that's in the best interest of the minor child. Those were Mr. McCarter's words, substituting in the word father for the name. This acknowledges that the court was required to independently evaluate the proof and make provision for the child that's consistent with the requirements of 36-6404B.
So it's your position then that the court could modify the visitation without any notice to opposing counsel or without a affirmative request from your client?
Well, father filed a petition to modify the visitation. So the modification of visitation of the schedule was the whole issue of father's petition. So that whole issue was before the court, unlike the case that he cited of Kiesling, where apparently it started out, it was a visitation case and they ended up arguing about custody with no notice of custody. So,
well, excuse me just a minute. The father asked to increase visitation, correct?
he alleged a material change of circumstance and asked for an increase. Yes, Your Honor.
So he was affirmatively asking for more visitation. What subsequently happened, as I understand it, is that the court reduced his visitation.
That's correct.
You attempted to file something to request a reduction, but apparently the court did not consider that. But the court, in its own volition, reduced his visitation. Would that be accurate?
That is accurate. Mother had the right to answer his petition and to respond to his statements, his allegations, and she did so with evidence that convinced the court that the circumstances had gotten worse, not better.
So was this reduction in visitation discussed? Was it tried by consent? Tell me about what kind of notice father was on before the court did this.
Your Honor, our answer denied most of the allegations that father raised about all of his bases for justifying a modification and an increase in his time. Everything that we had done in court, mother was responding, the other witnesses were responding to show the court that what father had alleged was not accurate and should not be relied upon.
Well,
So
and maybe I need to be more specific. How would the father have been aware that other than he was in court and the court can do what it wants to theoretically, but was there any affirmative request? Was the issue of a shortening his visitation time litigated or on the table, so to speak?
Your Honor, there was definitely testimony during the hearing from mother who, and I'm going to paraphrase, essentially told the court she didn't know. She would in some ways think it was in John's best interest for father not have any parenting time, but that she feared that would also cause harm to this child, so she couldn't really ask for that. So her testimony, yes, was as to the point of his parenting time should be limited.
She specifically testified to that or requested that?
Yes, Your Honor. She specifically told the court that she was torn. She, in one way, thought he shouldn't have any parenting time. And again, I'm paraphrasing. I don't remember her exact words, but that when child goes to father, and especially for extended periods of time, his behavior, his whole functioning was so much worse the longer he was with dad. So yes, there was specific testimony about that father didn't need any visitation for child's best interest, although there was the competing interest of this child is bonded with dad, does love dad, and to completely cut him out of the picture would have also been harmful for the child. I hope that answered your question.
I think it probably did as far as we can go right now. You may proceed.
The court's not bound to follow either parent's proposed parenting plan, and the failure of mother to have filed a proposed parenting plan is not fatal. There's case law in the brief to support that. But the court is mandated to craft a parenting plan that is in the child's best interest, which is exactly what he did. He took this matter under advisement after he heard all the proof, and then he issued his detailed 11 pages findings of facts and conclusions of law. The court considered father's request for additional time and mother's concerns that the child was adversely affected the more time he had with his father and that she was torn. The court took the matter under advisement, as I said, and created a plan that allowed the child to have time with his dad while minimizing the opportunity for harm, and also provided an incentive for father to comply with the provisions of the plan. Mr. McCarter read to you, I think, from the findings of facts, but in the actual judgment on page 74, the court allowed the mother the right to cancel up to 6 of his visitation periods per calendar year, and that's because there had been a history of father disobeying the court's order. And mother's only option was to file contempt petitions and come back to court and create more conflict or let it go. So this was what I consider a fairly brilliant solution to that problem, that she has the power to cancel up to 6 if she needs to. Now, as to emotional abuse, I know I'm getting close. Mr. Carter wants this court to adopt a finding that emotional abuse requires a physical component. This is contrary to the natural meaning of emotional abuse. Rather, it seems more reasonable that that statute that's referred to is not a case of a misplaced modifier, and that the reference to the definition does not refer to the definition of abuse, but perhaps of other persons living with the child, as it attempts to define under the domestic abuse, the section 5. Rather than evidencing bias, the court was required to consider the baseline from which it was argued that there'd been a material change of circumstance. The court evaluated the new testimony as it related to the previous testimony and findings, and astutely concluded that the father had not turned over a new leaf, but his behaviors had actually worsened. As to the attorney fees, as mentioned before, father had the opportunity to respond to the affidavit of attorney fees that was to be submitted. He did not file any response to that. The award of attorney fees is discretionary with the court, unless the court is found to have abused its discretion, and we would ask that that award be sustained. Additionally, attorney fees should be awarded to mother on the appeal, because since January 2012 through August 2020, if my math is correct, it's been 105 months, 8.5+ years. Out of those 105 months, litigation has been ongoing in this case for 94, only 11 months without litigation. And while Mr. McCarter explained to the court that as of the 2018 hearing, his client was called up on child support, it was not voluntary. It required judgment land and a pending sheriff's sale. The child support that mother receives is far outweighed by the attorney fees that have been incurred in 8+ years of litigation. It was conceded the material change of circumstances occurred, but they were not as the petitioner alleged. It's obvious that the court carefully followed the law, considering Armbruster Section 404, 406, and 106 as they apply to this child and his parents. And the court issued a detailed finding of fact and conclusions of law to support his judgment. Father was on notice that mother opposed his petition and set forth actions by father for his failure to comply with the current plan. And we ask this court to affirm the juvenile court in all respects. Thank you.
Thank you. We will hear rebuttal from the appellant.
Thank you, Judge. One of the things that Ms. Cothran said that I think I want to point out to you is she made the comment that she has the power. Well, the mom has the power. The order gives mom all the power. Even if you look at page 86 of the court record, volume 1. However, father has no right to assume that any change approved by mother will allow father to take future action contrary to the court's order, and mother must specifically approve any deviation from the court's order on each separate occasion. Essentially what this means, at least what I gathered from that is that the mother can dictate the terms in which the father sees his child. The mother can give more, give less, whatever she wants to do. And that, for instance, if the mother says, well, I'm going to start allowing the child to speak to you on Tuesdays and Thursdays every week, and that goes on for a year, the father doesn't have the right, if she takes that away, to go back to court and articulate a material change of circumstances under the failures to adhere to the parenting plan. He has no mechanism to come back to court, and how dare him if he is to question the mother in any sort of way. And so what the court has done is it's restricted Mr. Bailey's ability to have access to the court to change anything, to ask the court to do anything any differently than what the court has ordered in this order. And one of the things I would also articulate to the court is that each witness that testified, with the exception of the mother's husband, testified that father was a good father, that he was appropriate with the child. Even the mother's parents, who take care of the child, spend significant portions with the child, testified that they got a great relationship with dad, that he's appropriate, they were complimentary to the father, and that they noticed that the child loved his father, and he was often very excited to see the father. If you've got these sorts of facts, why would you restrict his time, or most importantly, why would you restrict the time with the child and his father? I would suggest to the court that this is an egregious ruling. There's no easy way to do that, respectfully to Judge Witcher. It just seems as if the judge was really kind of colored by past rulings, and that was the lens in which he viewed this case when we tried it on July 9th and 16th of 2018. I would respectfully ask your honors to reverse the order of the court. I would respectfully ask your honors to draft your own order. I think remanding this case back to the court would do more harm, and so I would ask that you reverse the court order. Thank you.
Thank you. Again, counsel, we appreciate your argument. We appreciate you participating in this process. Want to thank Mr. Hivner and his staff for putting this together and the excellent work of the AOC technology staff. We will attempt to get you an opinion as quick as possible. And with that being said, Mr. Hivner, you may recess court until the call of the next case.
This honorable court is now in recess until 11 a.m.
Thank you.